A new law fixes a major problem with Oklahoma family law courts. I'm Tulsa attorney James Worth, and I'm reporting regarding a new law goes into effect November 1st of 2024. It is HB 2478, and it fixes a big problem that we have. And that problem is getting initial orders in place and delays in the family court process. So particularly in Tulsa County, you can file a petition for divorce, put in an application for temporary orders, and you can't just get your temporary order hearing if there's kids involved. You have to go to a parenting plan conference, and then you have to request a referral to get permission to get it set for the temporary order hearing docket. And then even on that docket, a lot of times it's a cattle call docket, there may not be enough time to hear your case, in which case it may be passed to another date. And then if there's allegations of an investigation by DHS, that could be grounds to get that continued further. And beyond that, they're restricting the amount of time that you can have for a temporary order hearing. And sometimes they do this by proffer only, which means it's not actually witnesses and exhibits where you have an opportunity to cross-examine the witnesses against you. It is where you say, this is what the evidence will demonstrate at a final hearing, and the judge can make rulings based on that. It is not a substantive hearing. So those are the two big problems, that we're being denied substantive hearings, and it's taking way too long to get to a temporary order hearing. Because these orders are only temporary. They're only in place to protect the parties until we can get to a final trial, which can take a long time to get to, and you need those orders quick. Well, we've got the resolution, hopefully, to that. We'll see how it plays out after November, but it's called Alanda's Law, and it amends, primarily, it amends Title 43, Section 110, and what it says is that from the time that you file your application for temporary orders, that you are entitled to have a substantive hearing within 30 days. And then if there are allegations of domestic abuse, then that shortens it. And you're entitled to a substantive hearing to be initially set within 10 days. So it sets deadlines for you to be able to get into court, and it requires it actually be a substantive hearing, not just where you're saying what the evidence will show, actually testing that evidence through cross-examination and through an evidentiary hearing. It also has another provision in there, because that provision there only applies to matters for dissolution of marriage, divorces, and legal separations. However, it also notes that it amends Title 10, Section 7700-624, which notes that a temporary order issued pursuant to that section can include orders regarding custody and visitation, and that they can be done under Title 43, Section 110, which includes this new language that sets the deadline 30 days and 10 days. So that is good news for parties going through custody matters in the state of Oklahoma. It sets deadlines to get those temporary orders in place, and that's the best way to do it. You hurry and quick and get some orders in place on a temporary basis. And that gives you time then to do your discovery. You can slow things down a bit, get the evidence that you need, and be fully prepared for the full-blown final trial. But it's important to get those early orders in so that everybody knows how to conduct themselves, so that no one is being denied a relationship with their child unreasonably. Nobody's allowing alienation to occur over the months and months it may take to otherwise get an order. So we're very happy about this and hope this plays out well starting November 1st of 2024. If you're dealing with a circumstance in a court in Oklahoma for custody and visitation, you're not just going to want information from video. You're going to want to talk to an attorney privately and confidentially to receive legal advice. To get that scheduled with an attorney at my office, you can go online to makelaweasy.com.